I'm here on behalf of the appellant, the town of Selmer, and I'm here on a Rule 9 appeal, interlocutory appeal on two limited issues. Your Honors,
Did you want to reserve any time, Mr. Burleson?
Oh, I would like to reserve 5 minutes, if I could, please. Thank you. Your Honors, just briefly, the facts. It is a tragic set of facts here in the town of Selmer. Beginning in 2008, they had in the downtown area what they call the Rockabilly Highway Revival Festival and Car Show. And the town, the police department specifically, prepared a one-page traffic control plan to be used at that event. And it was used annually from 2008 up until 2016 on June 11th when this tragedy occurred. There'd been no problems with the plan. And what the plan called for was blocking streets with barricades and water barrels and cones and various type of traffic control devices so that there was a large multi-block area of the downtown area in Selmer that was used for a car show, for other type of events for attendees there where they would be in the streets, on the court square, and various places. The primary street that was blocked is Court Avenue, which runs right by the courthouse in Selmer. It's a 5-lane road, 2 lanes in each direction, a center lane. And the traffic control plan that was in place blocked Court Avenue at 6th Street in Selmer, which was about 3 blocks away from the actual, what I'd call the downtown area. And it had barricades, which I call sawhorses, that are marked orange and white, and these orange barrels that you often see on construction sites to close the road. That's the plan that had been used. The police chief, Neil Burks, had implemented that plan every year. There'd never been any problem. On June the 11th, 2006.
And that plan blocked all of the streets, is that right?
Yes, sir, it did. There was a perimeter plan. Court Avenue on 2 ends, and then there were streets a block or 2, and I'm not good on my directions. I think it's west of there that were blocked off, so that you had multi-block area that was blocked off.
Initially, you called it water barrels. Was it water barrels or just orange barrels?
No, sir, it was orange barrels. There was no water in it. They were empty plastic barrels that are a certain height.
Okay.
And I misspoke if I said water barrels.
You did, but okay, that's why I wanted to clarify.
I'm glad you did, because that's not correct. So on June 11th, Mr. Stamey, a 91-year-old driver, was in his vehicle with his wife. They went through the barricade, traveled several blocks, traveled 1,124 feet. After they went through the barricades, went by a car show, and there were people on the sidewalks and around the area, and struck Mr. Johnson and Ms. Duncan and killed them. He then proceeded on for another 1,000 feet or so and then stopped. So this lawsuit is based on a claim of negligence against the town of Selmer and other defendants who are not here. The Chamber of Commerce in McNairy County, the McNairy Economic Development Commission or District, and also an organization called AIM, Arts in McNairy, who participated in this festival. As far as procedurally, the town filed a motion for summary judgment in front of Judge McCraw. It was argued. He denied the motion for summary judgment, but subsequently, when we, on behalf of the town, filed a request for an interlocutory appeal on Rule 9, he granted it, and then of course we petitioned the court and you granted it. And so what we're asking today, Your Honors, we think there are 2 sort of foundational issues that we think where the trial court is in error, and this case should be dismissed against the town. The first is the application of the public duty doctrine. And we think that, that the case law is clear in a situation like this, that the public duty doctrine applies. The public duty doctrine it predated, as you know, the Governmental Tort Liability Act. The Governmental Tort Liability Act was passed in 1973, where it created the exceptions to sovereign immunity and the specific statutory exceptions. The Supreme Court has told us in subsequent rulings that the passage of the GTLA did not abolish the public duty doctrine. And the way they've told us to analyze the cases is look under the GTLA first, see if immunity is removed or not, and then if there is no immunity there, an affirmative defense that can be raised is the public duty doctrine, which is what we did here. The courts are then to analyze if the public duty doctrine applies, and if there is a finding that there was an affirmative action by the governmental entity or governmental employee that the plaintiff relied upon, then their immunity is removed. If there was not, if it's a general duty to the public at large, then the court is to look to see if there's a special exception. And Your Honors, under the facts in this case and the law that the Supreme Court has told us and even that this court has held, I think it's clear that the public duty doctrine applies and that the town of Selmer was immune from any negligent claim as a result of these incidents that occurred on June 11th, 2016. Under the public duty doctrine, private citizens cannot maintain an action against a public entity unless they are able to allege a special duty that was particular to them based upon an action of the governmental entity. A general duty to the public at large is not sufficient. Now, if in the record you've got the testimony of the police chief, Chief Neil Burks, the fire chief, Chief Carr, Anthony Carr, who both testified that the purpose of this one-page plan was for public safety, was for the general public and for safety. Whoever attended the event, that's who it was for. The plaintiff's pleadings themselves, and I've cited you examples of that in our brief on pages 21 through 24, talk about the fact that the purpose of this plan was to protect the public. And the courts have even said a duty to everyone under the public duty doctrine is a duty to no one. And I think that's what we have here in this case. And in terms of, so I think the public duty doctrine applies to provide immunity to the town. Then the question for the court is, well, does a special exception apply? There are 3 enumerated special exceptions. I think there's only one that is at issue in this case, and that's the first one. And that's if officials affirmatively undertake to protect the plaintiff and the plaintiff relies upon that undertaking. And I'd like to address that if I can just briefly. First of all, I want to state affirmatively that the town did not undertake to specifically protect Ms. Duncan or Mr. Johnson. Thus, the special duty exception does not apply. And you may say, well, why do you say that? Well, the case precedent tells us that the Supreme Court told us in Ezel v. Cochran that the special exception requires the existence of a duty particular to him or her, referring to the plaintiff. That's clearly distinct from a duty owed to the public in general. Now, the plaintiffs in this case, the appellees, are asserting that Mr. Johnson and Ms. Duncan were a subclass in that they were people who were attending the event, and thus they were in a subclass, and that was an affirmative action by the town to protect these folks. That argument has been rejected by the courts in Holt versus City of Fayetteville. I've cited it in my brief. That's an appellate court decision in 2016. A similar argument was raised, and the court rejected that. In Kimball versus Dyer County, a 2020 Western Section case, where there was a similar argument. A tree fell across a road, and a deputy found it, did not take any action. Plaintiff came along and was injured as a result of the accident and argued that there was a special duty exception, that the deputy failed to protect the travelers who were on that road. And this court said that subclass argument is not going to fly. That's the same argument that's being made here. So under the precedent of this court, the subclass argument does not have merit. There is no allegation, much less any proof of there being any specific communication or contact between the deceased Mr. Johnson, Ms. Duncan, and anyone with the town, such that the town could affirmatively express a duty to them that they could rely upon. And Your Honors, I think it's helpful to look at the case Chase versus City of Memphis, which is a Supreme Court case. It goes back to '98, but that's a case where the court found the special exception applied. The reason I think it's helpful and illustrative is my time just ran out. Can I steal some of my rebuttal time?
Well, let me ask you about that. Tell me about that case.
Okay. Your Honor, in Chase, the reason I think it's so instructive is there, the deceased, a lady named Miss Stidham, was having a problem with 2 pit bulls her next door neighbor had. She made a report to the city. The city came out, inspected the situation, and actually had a hearing to determine if the dogs were vicious or dangerous, different categories they had. They had a hearing, determined the dogs were dangerous, not vicious, and apparently if they were vicious, they could be taken away. If they were dangerous, the owner retained them. But the city put conditions on it. They said the owner had to repair the fence, and the owner had to send the dogs to obedience school within 90 days. The city sent out a letter to Ms. Stidham telling her this is the action we've taken. She had the right to appeal that had she wanted to, but she relied upon the decision of the city. So the city had direct communication with this specific plaintiff. Well, unfortunately, the plaintiffs did not comply with the order that was entered by their little court, and the pit bulls actually attacked, mauled, and killed Ms. Stidham. When she filed suit, the court found that there was a special duty exception because the city took affirmatively asserted that they were going to take action on this matter. Ms. Stidham relied on it, didn't appeal, didn't follow up, and then the city didn't do what it said it was going to do, and as a result, she died. That, to me, is an excellent illustration of what the special duty exception is, but we don't have that here because there's nothing like that where there's any communications or affirmation to Mr. Johnson and Ms. Duncan in this case where that they could rely upon.
Thank you.
You'll still have your rebuttal time.
Pardon?
You'll still have your rebuttal.
Thank you, Your Honor.
May it please the court. My name is Matt May of Rosenblum and Reisman of the Memphis Bar, and along with Mr. Gilreath, we represent the plaintiffs' appellees. Mr. Gilreath represents Mr. Johnson, the deceased, and I represent Ms. Duncan.
Will you both be arguing?
No, I will just be doing the argument today. Thank you, Judge.
Sure. You may proceed.
Thank you. We are asking the court to affirm the trial court in ruling that there was a particularized duty and that the public duty doctrine does not apply in this case. Appellees asked the court to review the facts of this case in the context of the Supreme Court's opinion in Ezell v. Cockrell. Here, plaintiffs have claimed that the appellant town specifically and voluntarily undertook a duty to decedents Johnson and Duncan, who were attending the Rockabilly Festival in June 2016. They did so by providing security and shutting off a heavily traveled highway. Plaintiffs have asserted that the town executed this plan and their duty negligently in the planning, participation, and execution of the event. This claim was brought under the Governmental Tort Liability Act under 292205. The trial court ruled that those the acts were operational and that the claims were permissible under the Governmental Tort Liability Act and that immunity had been waived.
But we aren't really addressing that issue today, are we?
No.
Okay.
And the court then determined that the public duty doctrine did not apply. In its simplest terms, the public duty doctrine shields a municipal employee for violating a duty owed to the entire community. In other words, as the rule goes, a duty owed to everyone is a duty owed to no one. The problem is that duty, determining this doctrine is not simple. Numerous cases from this court have gone through this fact-determinative approach of when the public duty doctrine applies. Appellees argue, though, that by looking at Ezell, the landmark Tennessee case on public duty doctrine, and reviewing the Supreme Court's opinion, the intermediate court's opinion, dissenting opinion, shows how the court struggled with whether the public duty doctrine should even apply. The Zell court finally held that the public duty doctrine did survive the GTLA, but it only applied in cases where a duty was owed to everyone in the public. Worth noting in that opinion, the public policy argument of the court was that it was upholding the public duty doctrine to, quote, prevent excessive court intervention into the governmental process by protecting the exercise of law enforcement discretion. That's not what we have in the present case. This is an event that is separate and apart from the exercise of normal law enforcement discretion to the public at large. The facts of Zell itself are illustrative of why we maintain that the public duty doctrine does not even apply. In that case, the police chief found 2 individuals who were intoxicated, decided to not arrest one. Later on down the road, the individual drove and struck and killed somebody, causing severe and fatal injuries. Because the police chief's duty was to the public at large for detaining intoxicated drivers, the court held the public duty doctrine shielded the police chief himself. The court went on to discuss the exceptions to the doctrine. Appellant is asking this court to jump straight to those exceptions. In this case, the special duty exception. We maintain that the public duty doctrine itself does not apply, that there was a particularized duty that the public duty doctrine should not even be applied. In Zell, the number of people to whom the police chief owed a duty was infinite. There were no identifiable people or persons to protect. In Zell, there was no limit in time or space as to who was placed in peril by allowing the intoxicated driver to drive. Same is true of the case where the tree fell in Dyersburg that counsel was referring to. There was an infinite number of people that it could apply to. It was not a particularized duty. Here, the people that the duty is applied to is those who were in the small confines of a highway that had been blocked off. There was a perimeter. There were festival goers that were promised that there would be security. I doubt anyone in this litigation would take the position that Ms. Duncan and Mr. Johnson would have been walking in the middle of the highway were it not for the defendant undertaking a duty to protect them. This occurred moments after Mr. Stamey drove through. In Zell, it was hour after the alleged negligence of the police chief. So,
Well, let me ask, from the time the festival started until the accident, how much time expired?
So there had been a significant amount of time. One fact that is that had happened, so there were hours that had gone by. The cones and the barriers were set up early in the morning. The testimony is that they had not been recently checked prior to Mr. Stamey driving through them. So we don't know exactly what condition they were in at that time. One fact that is very important is that a town employee, Clay McCullough, and this is in our brief, was assigned to actually be at the entrance where Mr. Stamey drove through. It was his job to be there. He chose to leave, chose to not tell anybody that he was leaving. His job was to watch the cones. His testimony was that had he been there when Mr. Stamey drove through, he would have tried to alert the crowd. He would have tried to do everything he could to stop him from striking people and individuals. So we maintain that there is a particularized duty that he owed. It wasn't like the cones were set up and left for hours where there was no duty of the town to make sure that they were sitting there. So we maintain that that would have been a particularized duty had he been there that they would have relied upon.
I'm trying to see how whether he was there or not impacts the applicability of the public duty doctrine, because the doctrine goes to whether or not there's a duty owed to the public generally, and even if you're negligent, immunity still applies.
Right.
So what difference does it make whether he left the scene or not in terms of application
Right,
of the doctrine?
in terms of application of the doctrine, one, we maintain that this is in the case law. I think it's Bridges versus City of Memphis talks about it, and jumping to the specialized class, talks about it being a particularized duty. That's what's here. We maintain that this was a subset, this was a particularized duty that one, that Mr. Johnson and Ms. Duncan relied on the town to provide the security. They would have not otherwise been walking on the highway. Two, that was affirmative by the city by putting the cones up. Another affirmative action, Your Honor, that I was going for was that they actually affirmatively stationed individuals there. So in other words, it wasn't a duty to the public at large. It was a duty to the people who were coming into the festival and who were anticipating that the city would maintain a safe perimeter for them. So that's why I think it's relevant that Mr. McCullough was stationed to be there and failed to do his job, and we believe was a cause of the eventual death of these two individuals.
You know, with regard to somebody failing to do their job, I see how that comes up in the context of whether or not the Governmental Tort Liability Act applies, because you get in that discussion about operational or discretionary. But here, on the Rule 9, we're not looking at any of that. We're just looking at public duty. And were they doing something to protect a specific person or subclass? Or was this for the public generally?
It was, I think that's where the confusion can come, is just because it was open to the public, appellant would have this court believe that that means that the public duty doctrine automatically applies. This was for particularized individuals who relied on the town to block off the street and to maintain a perimeter. They were walking on a highway that was typically, they would not have relied on the town to do its job and been walking in the middle of the street. So I don't think that operational, and that comes into play here. I think it comes into play the fact that the town chose, this wasn't a part of normal city day-to-day and police operations. That to me is where the Supreme Court in Azell really comes, and that was what I was just discussing in the public policy, is that by maintaining the public duty doctrine, they did not want courts and litigants second-guessing necessarily those day-to-day operations of the police and law enforcement in protecting the public at large, an infinite amount of people. Here we have a class of people who chose to come to the festival and rely upon the city to block it off and to be in a busy street that they normally wouldn't have been in. And that's where the trial court found it instructive, the Anderson versus City of Chattanooga case, that it was similar to the duty that was found there, where it was a police for a funeral processional, and it was found that it was negligent, and that they negligently were in their duty to handle the the funeral processional, and the court said that, our trial court here said that this is akin to that there is a subclass. Appellant also mentioned the Chase versus City of Memphis case, where and said that is instructive in this case because it was just to the neighbor. It's worth noting that in Chase, the court determined that the duty was not just to that particular decedent, but was to the neighbors themselves. We believe, though, that, like I was saying earlier, that the current state of the law, that the public duty doctrine itself should not be applied here. Even if the public duty doctrine does apply, that the special duty of care is applicable in this case. The special duty, number one, exception to the public duty doctrine is that officials by their actions affirmatively undertake to protect the plaintiff, and the plaintiff relies upon the undertaking. Town of Selmer appellant wants to jump over that second part. They don't discuss the fact that here, appellees were relying on the town to do its unusual duty of blocking off the street. Plaintiffs submit that if the town is correct that there's not a duty here, and they did not affirmatively undertake to protect decedents, then there's no incentive for the town and its employees to perform their safety assignments for special events such as this in a manner that would protect them. They would say that there was no liability because they're not going to be second guessed for doing their job correctly for a specialized event. This was not an event that happened every day of the blocking of the street. The trial court correctly found that a special duty did apply with a class of individuals. Instructive, again, is the Chase versus City of Memphis case where the town was found to be liable and the public duty doctrine did not apply. Anderson versus City of Chattanooga, as I explained before, that when they agreed to provide the funeral escort, they undertook a voluntary duty, as in here, where the town voluntarily undertook to provide security and to block off the street. The creation of the traffic control plan here demonstrates the knowledge of the risk to the attendees. The town would not block off a road unless you anticipate cars coming through. In each case of liability, that is where the public duty doctrine is discussed, the municipality creates a system that was not easily visible to the public, altering the ability of the public to take precautions on their own. Here, that's what we have. We have the decedents who relied on the town to do so, and the town who voluntarily undertook to have this particularized duty to these individuals. By doing so, the municipality voluntarily created this special zone of protection, same as with dog bite protection for the victims, the neighbors, same with the funeral escort. Whereas the cases that the town cites to is very broad, and in none of the cases that the town cites to is there a particularized duty to any certain groups. They rely upon a case that involves a warrant that this court determined that the public duty doctrine applied, where the warrant was not served because that was a generalized duty that law enforcement officers have to undertake. They determined that they rely on a case, again, where an officer chose to allow an individual to drive off and then to drive over an overpass. Again, that was a duty that the officer in his day-to-day service chose not to enforce. And so that's the type of cases that the town is relying on, not where there is this particularized duty here, where the town has undertaken to protect individuals and that where those individuals have relied on the town to protect them.
I see you're almost out of time. I wanted
Yes.
to ask you about your joint venture claim argument.
So we believe that not every claim would fall under the GTLA. And in our brief, we cite to several examples of how this is not we're not suggesting that this is a separate tort, but there's certain torts that the legislature has said, civil rights, for example, that flows outside of the GTLA. Further, this is more joint venture is more of a contract claim, and the legislature has allowed those types of claims to go against municipality because they're allowed to contract with private entities. So we believe that because the town, we've met the elements, there's a disputed fact of those elements necessary to prove joint venture, we believe that claim should be allowed to move forward to the jury.
But the damages that you seek are not damages you would normally seek under a contract claim, is it?
No, I do not believe it would be the overall damages for the tort itself.
You would
But
seek
right,
claims that you would get in a tort case.
right,
Is that right?
right.
Okay. All right.
Thank you.
Thank you.
Burleson, you have 5 minutes.
Thank you, Your Honor. I'll try to control my time a little better this time. Just a couple of things. First, Mr. May referenced the case of Anderson versus City of Chattanooga. Your Honor, that's easily distinguishable from the situation we have here. That's a case that the appellees relied upon heavily at the trial court, and they're asserting it today. The fact is, the public duty doctrine was not at issue in that case. I don't know, I can only go what's in the opinion, but that was a GTLA case, and as you know, the public duty doctrine is an affirmative defense that has to be raised. As far as I know, it wasn't raised. It's certainly not discussed in the opinion. So I don't think that case applies here. In terms of the subclass, the Holt versus Fayetteville case, to me, is a really good illustration of the rejection of the subclass doctrine. That's where the police officer stopped a drunk driver, failed to secure her properly. She got in his patrol vehicle, drove off, and hit somebody head-on and injured a bunch of people and killed a person. Another tragic set of facts. Plaintiff's attorney there tried to argue that there was a subclass of people who were on the highway where this person was and could drive. That's not the public at large. That's a subclass, and the court rejected that summarily and said the subclass is not appropriate. It's got, the duty has to be to a specific particular person, which is not in the proof here, Your Honor. In regard to the joint venture argument, Your Honor, I just want to address a couple of things on that. This is the underlying underpinnings of this case is tort, not contract. If there's a contract, it's between the joint venturers, not with the plaintiffs. What they're seeking is damages, tort damages for negligence against the defendants. So it's a tort claim, and I think that, as I've argued, the town is immune, but even if you go beyond that, it's inappropriate. Governmental entities are not allowed to share expenses with non-governmental entities. For example, you can't have a governmental entity can't have a contract agreeing to indemnify a private party. It's using public money for a private purpose. It's illegal, it's not allowed, and the legislature is the only entity that has the ability to approve that. So what I think the plaintiffs are doing is not appropriate, and we're asking you on both the public duty doctrine, I'm asking you to reverse the trial court on that, find that the town was immune and should be dismissed from this lawsuit, and also that in terms of joint venture, that that's not a valid claim against the town and it should be dismissed as well. Thank you.
Thank you, gentlemen. Thank you for your argument. We'll take the matter under advisement. May call the next case.
Carolyn M. Stark et al. Versus William S. McLean et al.